Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today, we have yet another breaking news episode on the Ripple v SEC lawsuit. Small, but still very effective, as you guys most likely know. Now, attorney Sarah J. Protzko has appeared in the case on behalf of Chris Larsen. Welcome to Team Ripple. Attorney Protzko's background can be found here. So, without further ado, without really much to talk about here, Ripple has got some reinforcements. Yes, the SEC, we just updated you guys a little bit earlier, got some reinforcements as well. And now Chris Larsen specifically himself got some reinforcements too. And here we can find a little bit about what she is about and, her education and bar admission apparently. And yeah, whatever you want to know about her, you can find on the Paul Wise website. It's not too important if you were to ask me. She still has her V card. that's pretty sorry, I'm not sure exactly what the V card is supposed to be. Maybe it's something to do in this lawyer world, but to me it's pretty funny that she has a V card. Yeah, no, you can basically find everything about her on this website with Paul Weiss, because that's, again, what she's working for. Now, the more interesting part about the lawsuit, though, and about the situation for right now is this article right here. XRP holders are accused of disseminating false statements about SEC leadership. Now, guys, I have been made out to be a lot of things, liar, this, that, very often, but the entire XRP community is now being accused of also putting up false statements. And to be honest, it is quite funny, because often the SEC, within this Ripple SEC lawsuit case, has taken on a defensive yet offensive approach of saying, no, we aren't doing something wrong. You are lying, or you are doing something very wrong. For example, John Deaton apparently was aggressive, apparently was trying to, at least as far as we know now, trying to stir up some false narrative against the SEC for his own personal gain and Twitter followers. And there have been multiple of those cases where the SEC has just been alleging things to kind of defend themselves, right? And one of the fun parts, I would say, is that we often talk about William Hinman, who now Ripple requested to have on a little seat, on a little pedestal to basically talk. We talked about him very often, and none of the things we say are really just speculation. Most of it is based upon fact, and other parts are basically just the dots linked together of facts that we know. It's not really much speculation. That's kind of the phase 2. The phase 1, however, is just whatever William Hinman said, for example, about Ethereum in the past. He made it clear in his speech that in his eyes, Ethereum is not a security. So why go after Telegram? Perhaps the $1.6 million in payments he received from a law firm that sits on the Ethereum Alliance during his tenure at the SEC had something to do with it. He accused as he further pointed the finger at the SEC. This is, I believe, John Deaton, who has been putting up some of these allegations. Are they based upon something? No. Well, yes. The question of whether or not this individual was biased making any decisions, or was biased or lobbied for, so to speak, to push Ethereum/Bitcoin into a certain direction. And that's, again, it's really a legitimate question. People should be worried about that. People should be wondering. Now, let's look at this article. The SEC claims that XRP holders are disseminating false statements about its high-ranking officials. The U.S. SEC claims that XRP holders are disseminating false statements about its leadership on social media in its motion to quash Ripple's subpoena to depose William Hinman, the former director of the agency's division of corporation finance. The community has spent half a year spreading conspiracy theories. Also debatable. I mean, conspiracy theory is only a conspiracy theory if it's, a conspiracy theory. I mean, in this case here, we're just linking the dots together that are factual and raising really important questions, which, I mean, it didn't really have to be a conspiracy at all in their own books if they just gave an answer to the question instead of dodging it altogether and not wanting to give up information. A key part here, for example, is we want to see Jay Clayton questioned, or we want to get a chance to ask Jay Clayton some questions regarding his stance on Bitcoin, Ether, and XRP. Very usual, because he was one of the key guys to sue Ripple. We want to know basically why, kind of one part, but also what went into his decision on Ethereum. Those are logical questions because he was one of the top guys in the US for crypto regulation. So, I mean, he can put it up himself. We can ask him something. It doesn't really matter to me how he does it, but We just want a proper rule book or a proper log of what exactly happened. And since we aren't getting that, people are starting to kind of put dots together, which is like, okay, so Jay Clayton could have had a very big bias because he's working for a company which would get millions, if not billions of dollars if Ethereum and Bitcoin were properly regulated in a positive sense. He works there, he's going to get some crazy bonuses. So, I mean, he later on went to work there again. It wouldn't be too crazy if he actually helped that out to make himself a nice little sum of money, nice little $10 million or something like that. Pick something. Not sure if he made 6, 7, 12, whatever, but we're talking about millions and millions and millions of dollars that he made. That's not a question. The only question is, did he do something in a sense that he shouldn't have done, potentially, for the money, right? If you guys get that. The community has spent half a year spreading theories. I wouldn't necessarily call them conspiracy, but I guess that depends on the depiction of the exact word. You might call them conspiracy theories. About Hinman and the ex-SEC chair Jay Clayton suing Ripple due to alleged conflicts of interest. I mean, personally, I think these are good questions. The SEC claims that making Hinman testify would increase the deterrent to public service. Okay, so what about that? This would set a precedent for a parade of similar requests to depose the agency's high-ranking officials, which I wouldn't be against. And here they've said the bar is too high. The motion states that the defendant's subpoena should be quashed since it doesn't meet its burden of demonstrating exceptional circumstances. There are strict limitations on deposing senior government officials. Quote, the purpose of the exceptional circumstances rule is to protect the mental processes of government officials. Yeah, okay, that's logical. It's kind of a normal slur to put up there, like, no, these are government officials. I mean, they should be protected because they should function in their duty and shouldn't always be questioned for what they do. They have sort of an immunity. Well, yeah, until push comes to shove, right? Like in this specific case. And it's funny, if you actually go through the exhibits, which we did a little bit earlier yesterday, you actually saw that Ripple went over most of the SEC's points in their motion to quash already. So what that means is basically the SEC put up a motion to quash the deposition. So they are trying to make sure that William Hinman doesn't get questioned. A couple weeks prior, though, Ripple already put up a couple of arguments as to why they should be subpoenaed. Like a whole list of arguments, a whole watch list of why William Hinman should be put on a pedestal, basically. And so it's kind of funny how they're saying the bar is too high when Ripple literally explained why it's so extremely relevant. So to me, they didn't really give a proper response to Ripple's arguments. They basically just gave their own reasoning, which isn't really coherent. It doesn't really stick together quite properly. The purpose of this exceptional circumstance is to protect the mental processes of government officials in order to promote open channels of communication within the government. I mean, I get that from a certain perspective too, right? You gotta, of course, look at it logically too. I mean, if there's officials talking to each other, from a certain perspective, I can see it, for example, in the Netherlands, there's also a couple rules like that, and just generally speaking, if they could be prosecuted for anything they say to each other, they would be way more conservative and you couldn't have a good debate. You couldn't have proper rulemaking. I get that. And encourage qualified individuals to hold public office. But make sure you understand this from my perspective too. Like, if one of those SEC officials were to talk to the other guy about really banning every crypto altogether, I personally think, he can say that without any further judgment upon him. Because again, it could be a proposal, it could be anything. But if, for example, the SEC has openly, within their closed doors, discussed, openly within closed doors kind of sounds stupid, but you guys get my point, the status of XRP, for example, or discussed that some of the guys have bought XRP and they all think it's fine, for example, or they said, no, let's not sue Ripple because it's good, and then a little bit later they said, no, let us sue Ripple. Why? Because I say so, for example, Jay Clayton. That type of stuff could be really relevant to this lawsuit because the fair notice defense, which basically means that the SEC didn't give Ripple fair enough notice and a due process. Well, again, that one might hold up then. So it's a really difficult question. Prioritizing the mental processes or justice. Hinman has no first-hand knowledge, this is again what they claim, the SEC, Ripple claims otherwise, of the facts relevant to Ripple's fair notice defense, which the SEC claims is too insubstantial to justify the deposition. Again, Ripple says William Hinman does. Moreover, the SEC points out that a similar request in the Kik case was rejected by the court. I think that's a really difficult scenario to point out though. The Kik case, it's completely it's not necessarily irrelevant, but a completely different ballpark to what we are witnessing right now. Because Kik is, easier to debate, I would say, than XRP. As with XRP, all they want is just Bitcoin and Ether documents, and they're not given that, so they have to go through other means. And I just think it's completely different. I don't know exactly how to explain to you guys. Kick, the whole Telegram Kick case, all of that stuff is just, yeah, it's in a different ballpark. And now, since Ripple and its executives are facing civil charges, the regulator claims that they shouldn't be given greater latitude than criminal defendants. Yet again, they are not being questioned. They should not be given greater latitude than criminal defendants. Okay. Okay. And that's, again, what they did themselves. The executives are facing civil charges. Okay. I just had to quickly get that in my head as well. And as reported by you today, the SEC also pointed out that XP holders were using profanity and physical violence references to intimidate high-ranking SEC officials, which I don't really know too much about. Maybe some guys put that up here. Let's quickly check it out. This is from last month. SEC claims XP holders are too partial, citing physical violence references. I believe this was about John Deaton too. Yeah, Attorney John Deaton has denied promoting violence against the SEC. Moven's counsel John Deaton is also being accused of attacking the SEC, and Moven's counsel uses profanity and references physical violence in public attacking the SEC and its staff. In its initial reply, the SEC cited 2 occasions when Deaton resorted to physical violence references. For example, in response to a report about a discovery dispute in the matter, Deaton tweeted on March 12th, "There's only one way to deal with a bully. Punch that MF in his face. I'm up at 3 a.m. for a reason. Profanity. See you soon, SEC." And on March 3rd, John Deaton posted a video that he described as mock cross-examination of Chairman Jay Clayton, containing many inflammatory statements, including a supposed drug use, and that Deaton might have to walk over and slap the profanity out of Jay Clayton. Interesting, very interesting. Deaton denies promoting violence. In turn, the Movens claim that SEC is attacking the messenger by portraying Deaton as an unhinged conspiracy theorist crusader. The council denies inciting violence, downplaying his above-mentioned comments as satirical and humorous. For the SEC to use the above scenario and imply or suggest that Attorney Deaton was promoting violence or drug use is sad and pathetic. Yeah, this last part is true. It is a clear attempt to cast Attorney Deaton as the most unfavorable light, hoping that it will have a negative effect on the motion to intervene. Yeah, what a stupid ass situation, but all right. Guys, that was it for my little update here on the lawsuit. Just wanted to quickly give this to you guys and then move on. We have more videos coming, so make sure you subscribe to the channel and let me know what you think about the situation here. What a crazy situation, man. This entire lawsuit is making my head spin, making me sick, man. Come on, fix it already.